Hi, I'm Neil Cooper, and the following is my first draft presentation for Laws 099 Intellectual Property Law. The task is to explain the legal purpose for marking a copyrighted item with the enclosed C, the name of the owner, and the year of first publication. So the legal background. In Australia, the Copyright Act of 1968 allows that copyright is free and is automatic upon creation of the works. Copyright is not dependent on registration, notice, or any other formality. As such, there is no current legal basis requiring the use of the copyright notice in Australia. This has not always been the case. Australia is party to a number of multilateral agreements and treaties, including the Berne Convention, the UCC, Universal Copyright Convention, TRIPS, the trade-related aspects of intellectual property rights, and the World IPO Copyright Treaty as examples. The Berne Convention embedded the idea of copyright on creation, and the removing of constraints of registration. Not all countries agreed and remained outside the Berne Convention with domestic legislation or alternative multilateral agreements. UNESCO, through the UCC, sought to provide an alternative convention. UCC allowed Berne parties to hold to the Berne Convention, and those not aligned to hold to their legislative copyright notice provisions, as long as they generally aligned with the UCC Article 3 Clause 1, which every published copyrighted required the copyright symbol, the name of the owner, and the year first published. The US legislation had such provisions, hence it's largely in everyday use. Since conforming in 1989 to the Berne Convention, it's no longer mandatory for copyright to exist, even in the US. So, legally not required, but still may have some merit. The Copyright Act in Australia uses the terms within sections 30, 738, 102 and 103, which are the sections dealing with infringements. If a person or importer knew or ought reasonably to have known that the making of an article constituted infringement on copyright, the question is, should they have ought reasonably known? If it's noticed, if it's printed on the device or image or CD, it's hard for them to argue they didn't or not ought and are reasonably known. So copyright formalities have some practical value as deterrent against infringement. Where copyright notice provided, it falls to the defendant in the infringement proceedings to demonstrate that copyright does not subsist or is not owned by those identified in the notice. And quite simply, it serves as a reminder to those would-be users that the works are subject to copyright and permissions may be required. Not required, but may be useful. Thanks.